Um, Good morning. I'm Ian Ross Singleton. I'm an adjunct lecturer and a member of the PSC, the Professional Staff Congress at CUNY. I'm on the executive committee at the Baruch chapter of PSC. This is a teach-in today for students. I consider myself an eternal student, but I want everybody, especially those affiliated with CUNY, to know this is about students. This is for the students, for students. My students, I teach in the first year writing program at Baruch, and my students are about to begin research inquiries. So this is my demonstration of a research inquiry. It's how I took something that was personal to me and made it into something I think beyond myself. Not made it into, but began to do research. Right now, especially now, in this crisis, this time of crisis, you should all stand up for each other. And the best way to do that is to use what you have. All of you have your labor, your work. And it's your choice whether to withhold that work, that labor. If you and your coworkers decide to do that together, then you have a strike. Those of you unfamiliar, I had made some slides for you to look at, but I think it's pretty clear, everybody understands that. The strike as a tool, I think, is the most important you have for standing up against things like you or your coworker losing your job or your healthcare during this crisis, this pandemic. I brought up a strike in a meeting with somebody higher up in the PSC, and somebody mentioned to me the Taylor Law, told me to look it up. So I did, and I started asking questions. I reached out to Marc Kagan, who's going to be speaking today. I reached out to James Eterno, and I reached out to Vincent DiGirolamo. I hope you're all going to join me in the discussion today. And I actually hope to have a follow-up event to this with perhaps with people, lawyers who have a legal knowledge of the Taylor Law, and we could talk more about the legal aspects of it, although I think that'll come up today. I also hope, so I really hope that this event will become the beginning of an ongoing discussion. A discussion of a law that takes away a fundamental right of the worker, which is their right to withhold their labor. Simply because it's a law doesn't mean it's right. My whole motivation here is to demystify Taylor. And I hope that that'll be for everybody here, so that you, if you've been told that Taylor means you don't have a fundamental right of withholding your labor, and that conversation should end right now, well, I hope that this is an invitation to begin that conversation again. I've already learned a lot. There's a lot of context here, obviously. If you don't understand something, please don't worry. Ask a question. That's all I did. In the first place, I just asked a simple question. And that is not against the law to ask questions. Those of you who do know a lot about Taylor law and about striking, I ask you to be patient and use any questions that might be obvious to you to further flesh out the discussion. I know a strike is scary. It's scary for you, but it's also scary for management, for bosses, for the administration. The organizer, Jane McAlevey, said that it was really great that so many people came to the Women's March in January 2017. One of those people was my mother, to protest, obviously, the most misogynist president we've ever had. And that is very powerful. However, it seems that he didn't really even notice. If we had had a general strike, if there were a general strike that day, maybe he would have noticed. That's the power of this tool that I'm hoping to discuss. McAlevy's dissertation sponsor, Francis Fox Piven, argues in Poor People's Movements that popular movements have their own logic and direction. So I think in this case, the Taylor law is not the logic that, or the direction that unionists should be taking. It hinders union power, in short. Striking is the most important collective action that a union can take. The Taylor law is detrimental to this action and detrimental to unions. The ILO, International Labor Organization, has determined that the Taylor law is a human rights violation, specifically violating freedom of association. And that'll bring me to my first question, but first I'll introduce our speakers this morning. Marc Kagan is an adjunct lecturer at the Department of History at Lehman College, a CUNY graduate student and former Transport Workers Union and Local 100, former officer of that union. James Eterno is a blogger and member of the Independent Community of Educators Caucus of the United Federation of Teachers. And Vincent DiGirolamo is a professor of history at Baruch College, chair of the Union chapter, and author of Crying the News, A History of the American Newsboy. So I'll unmute people and I think we get started. Marc, you go ahead and begin.
Hi, good morning. So I think actually this idea of a research inquiry is really a neat idea, and so I'm a source in that sense for the research that that Professor Singleton is doing, and I'm going to mix both. I'm going to be providing him and you with facts, but also my own analysis. And, you know, you should keep in mind that other people's analysis may be different, right? And in a true research inquiry, you'd want to hear from a variety of people and ask questions of them and see how their answers were similar and different. So I want to talk about the Taylor law in the context of COVID and the financial crisis and the near strike at Hunter College campus schools. That's Hunter High School and Hunter Elementary School that almost took place yesterday, Tuesday. And my general premise is that while the purpose of the Taylor law was, when at its initiation in 1967, was to prevent worker and union militancy, over its 55 years of existence, we as workers and unions have become more fearful of action than we should be. And part of this is a sort of psychological reluctance to act that goes beyond the material concerns and is self-imposed. So the Taylor Law is a broad set of laws that are supposed to or written to provide labor peace. It establishes the way workers choose a union, the way the unions operate and collect dues. It prohibits management, whether that's the state or a city or a town, or in this case, CUNY, from making unilateral changes to contract terms, including both money issues and work conditions. In its most well-known section, prohibits both strikes and what is called concerted job actions, that is, ones that are taken collectively by groups of workers, and it can impose penalties on workers and the union for violations of the law. So specifically, workers can be fined an additional day of pay besides any money they lose from not working. So it's sometimes called 2 for 1. Unions can be fined for breaking the law, and then additionally can lose dues checkoff for an indeterminate period of time. So let me explain that. Unions have members pay dues, and in my union, the PSC, those dues are 1% of salary. Those dues are automatically deducted from my paycheck. If the union loses dues checkoff, that automatic deduction goes away, and it means the union has to collect directly from its members, either hand to hand or getting people to sign up for automatic credit card deduction, for example. But invariably, if some people are ticked off by, let's say, the outcome of a strike, they may decide not to pay dues. And under those circumstances, they're no longer in good standing. It means they can't run for office. They can't vote in union elections. In some unions, they can't even vote on contract. And since they owe back dues, even once the checkoff is restored, even once the automatic checkoff is restored, and you're paying dues again, you remain in what's called bad standing, perhaps for the rest of your work career. And of course, those dues sustain all the services that the union provides to its members. And so for this reason, what we've seen is that unions are actually more fearful than workers themselves of striking or of job actions. And finally, the Taylor Law says that if disputes can't be settled between the union and whatever the government entity is, that there's a series of third-party fact-finding, mediation, and ultimately binding arbitration to settle those disputes. And an arbitrator, for example, can impose a contract or make a decision about a dispute, although that may take a long time. Now, in fact, the Taylor Law has worked as its writers intended. It has worked to prevent strikes. Since 1976, there have only been 2 strikes in New York City, both by transit workers in 1980 and 2005. In the first case, I would say the workers themselves won. That is, they improved their lot by going out on strike. In the second case, it was sort of a draw. In both cases, however, the union as an institution lost substantial funding during the period that it was without dues checkoff. Now, traditionally, the argument by worker advocates is that the Taylor Law ties a union's hands. So first of all, those contract arbitrators that I talked about, in the case of a dispute that can't be settled, they tend to follow an objective of don't rock the boat. And there's this idea called pattern bargaining, where all unions in any particular kind of contract round get the same, have the same results. And this prevents really substantive changes in not only in wages, but in work conditions. So for example, in the PSC, the whole question of how adjunct faculty would be treated is a real substantive change. The lack of deadlines, because if you can't go on strike, then there's no real deadline, means that contracts sometimes go unsettled for years. In the worst case scenario, my union went 6 years without a contract. The law prohibits bargaining of some issues, such as issues affecting students or members of the community. So, for example, the PSC is prohibited from bargaining about tuition. And in a crisis situation like COVID, where long-standing contractual procedures no longer work, CUNY can just sit on its hands. I mean, the idea that a dispute will be resolved in a year or two is obviously unsatisfactory or even dangerous. And that brings us to the Hunter campus schools, where an extraordinary amount of union organizing went on in the last few months around issues of work and health safety, of workers' right to participate in evaluating whether their workplace, the school building itself, was safe to reopen. So notice how the Taylor law is one-sided here. CUNY announced that the school was safe. CUNY announced that workers are supposed to report on a certain date. CUNY refused to meet with the union for months. When it did meet, eventually, the meetings were short and were curt. It refused to hand over safety documentation. It refused to let union inspectors into the building to look for themselves. And when some teachers went in, just to kind of to prepare, they found that the safety changes that CUNY had announced that they had done were in fact not implemented. So notice the one-sidedness of this law. Where is the labor piece here? What is the mechanism for the union to challenge problems in real time instead of after the fact? There is none, actually, other than to strike, or at least to threaten to strike. And when these 125 workers do so, if they struck, the entire union of 30,000 workers is imperiled by the loss of dues checkoff. That's the hammer that the Taylor law holds over the union's head. However, in this case, the union chapter held a strike authorization vote, and the membership approved it overwhelmingly and set the deadline of yesterday morning. While the union leadership approved all these steps, it seems pretty clear that they were membership driven, that they were rank and file driven. These workers were seething, and they were prepared to act, fully understanding the potential legal consequences. So this is pretty extraordinary, but it should also be illuminating as to the possibilities that exist that we, labor, have largely set aside. And it seems like it was this deadline that forced CUNY to finally agree to allow the inspections to take place the evening before that deadline. But if CUNY had not allowed this, then in this case, it was apparent to CUNY that those 125 workers were fully prepared to strike. And that was a good thing, in my opinion. First of all, it forced CUNY to bargain after 3 months of stonewalling the existence of a deadline. And one teacher there told me in August that he felt like CUNY treated the union, their chapter, as a pesky fly. In other words, like, well, pesky, but ultimately no harm could be done by that fly. And clearly by Monday, CUNY realized that workers could do some harm, could bring power to bear. Now, if they had struck, it would have broken the psychological barrier of public employees that you can't strike, or that only transit workers can strike. Now, I think that's very important. It's not just that there have been no strikes, but that there's been no readiness or willingness to strike if necessary. This tool that can change the balance of power has been lost. We need to put that tool back in our toolkit and decide when to take it out. We have to be willing to seize the moment if we see that opportunity. And that's about mindset as well as law. And not just strikes, but all sorts of job actions, slowdowns, what are called work to rules. In the spring, there was discussion in my union of withholding grades until the last day, or perhaps beyond. And I'm personally convinced, I can't prove this, but I'm convinced that the PSC could have told all its members to withhold grades until the last day to protest the destruction of CUNY. And the New York State Attorney General would not have wanted to go into court and say that we were in violation of the Taylor law. Now, I can't say what would have happened if we'd gone beyond the last day to submit grades. That's a different matter. And the CUNY case, we have seen these extraordinary increases in class size on some campuses. We should be seriously thinking about how to screw these up. Could we cancel all tests or stop assigning work or other things? Again, this is mindset of unions and the rank and file too. Can we imagine taking action in the workplace around our demands? You know, we're in this remarkable moment right now. Someone said we're on the knife's edge between like utter calamity and real possibilities. So we shouldn't be rash and just act without thought. We need to be mindful in what we do. We need to be organized enough that when we act together. But also, we should be willing to be bold, right? Eterno law is meant to keep us from thinking big thoughts, to believing that a better world is possible. I'm not just arguing that we should be willing to seize the moment, but also we should understand that our actions can actually create the moment. What would Cuomo do, for example, if we shut down CUNY for 2 days about budget cuts or about making CUNY free? Could it turn into something? You know, how? The world is changing under our feet. Who will be the spark? And could we be that spark? I mean, these are just issues that we should be willing to think about.
Thank you, Mark. I have some questions, but first, James, did you want to say anything? And then Vince, you said you had something to say. Okay, Vince, I'm gonna go ahead and.
Hello?
Oh, hi. Hi,
Can you
James.
hear me?
Yes.
Yeah, sorry about that.
Okay.
My 2 kids are working on the family computers for their remote learning. So I'm doing this from a smartphone, which is not so smart. So forgive me in advance.
Okay.
I say a few remarks about the history in terms of the teachers' unions, because my background, I'm a longtime teacher now, happily retired, and do some part-time work at Hunter College, actually. I was the person who ran against Michael Mulgrew for UFT president in 2010. Just so you know where I'm coming from, I'm a longtime dissident within the UFT, and I'd like to piggyback on some of the remarks that were just said. But first, just a little bit of the history. You all learn in high school, everybody learns in high school about the Wagner Act and how that's sort of the Labor Bill of Rights, making collective bargaining legal throughout the country. But we often don't talk about how the public sector was not included in the Wagner Act. Basically, it's really strange because tenure for college and K-12 teachers goes back to like 1917, sometime around there, but collective bargaining rights were forbidden. And they passed a law in 1947 in New York State called the Condon-Walden Act. And what the Condon-Walden Act did was it made striking illegal. And you think the Taylor law is bad, the penalty there was dismissal. And if you got your job back, you were on probation for 4 years. So it was a very draconian type law to keep teachers from even, or any public sector employee in the state from even thinking about striking. We went on, and there were several groups within the teachers movement in New York City who were trying to organize, and the holy grail at that time was collective bargaining. Had to have collective bargaining. And Senator Wagner's son happened to be the mayor of New York City, and he was seen as a reformer, and this is great social democratic time for the city. Things came to a head because of all of these groups. The main one were the Guild, which was a little bit more conservative. There were many left groups, and a group called the High School Teachers Association. And the group that took action in 1959 was the High School Teachers Association. And they did it in the evening high schools. There were a bunch of evening high schools throughout New York City. And they basically got around the law by saying, we all quit. So all of them resigned at the same time, led by two men, what were called Young Turks, Roger Parente and Sam Hochberg, and they led a strike. And it doubled the pay of evening school teachers from $12 a night to $24 a night, which doesn't seem like much now, but if put it in 1959 money, that was a hugely successful strike. And throughout the faculty rooms in New York City schools, people took notice. And by 1960, there was a merger of the Guild and the High School Teachers Association, which formed the United Federation of Teachers. The UFT immediately almost went on strike in 1960. And it was successful because they got a commission and they were going to get collective bargaining, which they did eventually get. 1962, another illegal strike by the UFT under that repressive law, that Commonwealth law, and they won again. This was a one-day strike, and later they achieved significant raises. The UFT was run by Charles Kagan, then Al Shanker was his successor. They moved away those high school people as kind of too militant. But in 1967, the union went on strike again. And 1968, I really don't want to do too much about the 1968 strike because you'll end up with a whole nother issues on community control and the union saying it was due process. But anyway, they had struck against these laws. But after the 1966 transit strike, the government said, all right, this Condon-Wadlin thing isn't working. And they came up with the Taylor Commission and the Taylor Law, because they said the penalties were too crazy under the old system. So they had to do something that was a little bit more reasonable and could be applied. Well, the Taylor Law has basically done what it was supposed to do, which was cut down on the number of strikes. The UFT's only strike since the Taylor Law really is 1975. And that is at the point when the city was basically broke. So during the financial crisis in 75, the teachers went out and the leadership under Al Shanker really didn't want to strike, but the membership was like, this is ridiculous. The class sizes were outrageous. They went out for a week and basically came in and got nothing. This union still saved the city, not just the UFT, but many city unions, by buying the municipal bonds. The MAC bonds, I think they were called at the time. The strike told the teachers, because the fines came a little bit later, you better be careful about this because it's an expensive proposition. And for the union, they later lost that, what was talked about before, the dues checkoff, which meant the chapter leaders had to go get the dues money from the individual teachers, which was not easy. So the UFT learned the strike weapon is basically off the table. Transit workers, as was also mentioned before, had 2 strikes under the Taylor Law in 1980 and 2005. I was looking through Josh Freeman's book on working class New York, and I would argue that the 1980 strike was quite successful because they upped the original offer quite considerably for those workers. But when you put in the fines, the 2-for-1 fines, the workers felt they didn't achieve their desired goals. And I would say the same thing happened again in 2005 when Roger Toussaint led the transit workers out on another strike. And again, those penalties that came in and crippled the union made that feel like it wasn't a successful strike. But if you look back at it, it really was something that worked, and it's the most powerful weapon that a union has. I'd like to say there's one thing on the Taylor Law which keeps things going. Again, it was talked about before, and that's the 1982 Triborough Amendment. And what Triborough does is it keeps an old contract going until you have a new one. So management can't take things away from the workers. They can just hold the status quo for as long as it takes. It was talked about before how CUNY went, or PSC went 6 years without a contract. I believe the Buffalo teachers kind of broke the record. They went 10 years without a contract under that status quo doctrine. If the status quo doctrine wasn't in effect when Michael Bloomberg and Joel Klein came to break the New York City Teachers Union and were in some ways successful, he proposed a 9-page contract or 8-page contract, something very small, which would have basically obliterated teacher rights in New York City. The union was able to hold out because of that. But bringing it into this century, well, one more thing on the last century. In 1999, there was a very successful strike of Yonkers teachers, the Yonkers Federation of Teachers. It was not about money, it was about programming, and they didn't want this block programming stuff. And I remember we were at the UFT supporting them, and the famous incident there was when some of the kids went into the high school buildings there and were just throwing stuff out the windows, and that got management to settle rather quickly after that, because the people who were the administration and whoever they brought in as strikebreakers could not control the schools. So it is a powerful weapon, and as was mentioned, the International Labor Organization says this provision of the Taylor Law. There are good things in the Taylor Law, which about organizing and collective bargaining, but the provision outlawing strikes is a human rights violation. In 2018, when Cynthia Nixon was challenging Andrew Cuomo for the Democratic primary for governor, this was raised, and one of Nixon's platform pledges was to get rid of the 2-for-1 penalties in the Taylor Law and the anti-strike provisions. Cuomo's argument against that was the unions don't even want it. Okay, so in a sense, the union, the institution of the unions, in many ways, is helped by the status quo because it gives them a lot of central power, and it takes away that power from the rank and file. So I believe Cuomo was telling the truth in that a lot of the union leaders and public sector unions don't want it. Of course, there are exceptions. Around the country since 2012, when the Chicago Teachers Union had their first strike of the 21st century, teacher unions have been rebelling. The West Virginia strike, of course, probably the most famous, then Chicago, LA, and others like Oakland in the last couple of years. So the strike as a weapon is back on the table. And in this COVID crisis, the UFT actually talked about and threatened it. But my wife, who is an English teacher in the city system, said right from the beginning, stop. She said to me, stop, James. They're not serious, and you darn well know it. Okay, I went along, so did a lot of other people, because it was getting rank and file members involved, which was great and is great. But we knew something was going to be settled, and it was. Whether that is being adhered to, because you talked about the Hunter College campus schools, and they got those inspections. But whether things like a nurse in every school, proper PPE, things like that, whether that's being adhered to in all the schools, my reports say you got to be, oops, sorry, you got to be kidding on that. But that's where we're at right now, and we'll see where it goes as this situation continues to unfold.
Thank you, James. Yeah, a lot of the research that I've done has come from your blog. So, and my wife is also an English teacher, so I'm also doing childcare. Actually, while you were speaking, I had to do a little bit. So I feel you. I'm gonna ask Vince. Do you wanna go ahead?
Okay, I'm anxious to hear what the students' questions are, but I have a few just to sort of maybe set the table. One is that there are a lot of costs to violating the Taylor law. You know, the fines, the lack of the loss of dues checkoff, the lack of the Triborough Amendment, which continues our existing contracts. So those are serious, but there are also other costs, and I'm thinking here of the public, the support of the public, the support of students. To what degree will these strikes or job actions, even like a grade strike proposed last spring, to what degree is that punishing our students? So I want to put that into our calculation whether we decide to use the strike weapon. Number one. Number two, this gets back to Hunter. I'm interested in the role of health and safety as a unique kind of cause of a strike action, of a walkout. And I'm just wondering how that differs. We do not want to risk our lives by entering a building that is not safe. That's different from wanting a raise or fewer class hours or whatever. And so it seems to me, I'm curious what leeway we have in terms of health and safety by staging a walkouts. And curious too with Hunter, what was the role of the parents and the students in that matchup? So those are two things that I'm interested in hearing about, and so let me just stop there right now.
Yeah, I there are many students here, my students, and I would love to hear students talk about that. So, and I have some questions too related to that, but I'm going to go ahead and just move on to people who've already been putting in stacks. So, Marian, did you want to ask a question? And then please, I urge, especially students, let's discuss how you would feel about something like a grade strike.
Okay, well, I'm like James, I'm a member of the UFT, United Federation of Teachers, and James already mentioned that in the late summer, the president was talking about possibly a strike, and questions came up within the rank and file group that I'm a member of, the movement of rank and file educators, about the Taylor law, that even though I felt that I knew quite a bit about the Taylor law, I didn't know the answer to. So in a way, this is kind of like a research project for me too, which is why I'm here. So I'm gonna throw some questions out, and I think they would perhaps apply to the PSC if they chose to strike. Now, the first question is, if you actually read the wording of the Taylor Law prohibition against strikes, the only word that actually uses that it prohibits is a strike. It actually, the word concerted action, to my surprise, doesn't appear in the actual law. And I was wondering if that was a result of PERB decisions, that there were PERB decisions that were made that sort of are binding, are precedent going forward, that mention that concerted actions, such as getting together and agreeing not to give grades until the last day, that would be considered a concerted action. Another question that came up was who makes the decision whether the penalties are imposed? Because it's not automatic. Someone has to decide, to enforce the law, to enforce the 2-for-1, to enforce the hiatus and the dues check off, to enforce the fines on the unions. Also, I wanted to say a little something about the role of a safety strike, because and I wanted to ask if anyone, any of the panelists knew a bit more about this, because there is a Supreme Court decision. It's called Whirlpool versus someone or other. And it does lay out conditions under which, across the board, workers have a right to strike, whether or not they're organized, or whether or not they're currently covered by a contract that has a no strike provision. And I don't know if anyone is familiar with that, but there is a Supreme Court decision. It's the Whirlpool decision. And I'll just stop there because I do want to hear. Of course, I think the students take priority.
Thank you, Marian. I just want to add to that, and then I'm not going to try to answer those questions. But I am curious how, based on my reading of, as not a non-lawyer, my reading of the no clause strike sounds like it would prevent a public employees from even having a strike authorization vote. Yet I've heard time and time again that that's not illegal. So how does that work? I mean, what you asked Marian about the concerted action, is it because nobody's going to actually prosecute it, like you were saying, Mark, or how does that work? So maybe if you could elaborate on that.
Yeah, this is an interesting question. It's a whole question of discretion. So, for example, in 1999, transit workers held a mass meeting on the eve of their contract expiration. And the mayor at the time, Rudolph Giuliani, got an injunction barring even the advocacy of a strike. And the union leadership took that very seriously and came to the mass meeting and read the injunction to workers and then left. And the dissident or the oppositionists within the union took over the meeting because they now had this opportunity to do so. And workers there, 4,000 or 5,000 workers, held a strike vote. So but then there were no penalties imposed. No one went to jail. No one was fined, despite these onerous provisions of $25,000 for each advocacy mention. So there is this question of discretion, right? And workers not often, but workers have engaged in what we might consider job actions or work to rules or slowdowns, and an agency, an entity of government can choose to ignore them, right? To not treat them as territorial law violations, to not seek sanctions. And similarly, the state attorney general has discretion on what to deem a territorial law violation. And I think what Vince raised about health and safety is a really good point, right? Because this does have a different aspect than just saying we're striking over an additional 2% wage, right? And we don't have any actual experience with it. It is technically a territorial law violation if you are striking, but whether anyone would choose, any government official would want to pursue that in court, or whether a judge would feel that workers weren't provoked into a strike on that basis is unclear. We just don't know. We have no case law on it. And finally, I'll say someone, was it Marion that raised that only strikes are prohibited and not job actions or work to rules? But there's in the law itself, but there's been 45 years of court decisions on what constitutes this. And so it's on the one hand, it is very wide ranging, like what can be considered concerted job action. But then on the other hand, there are times when clearly things that were concerted job actions have not been treated as such because no entity wants to open that can of worms.
Thank you.
Yeah, thank you. So I wanted to move on to Erica Labrada's question, and I just had a question about this. If you want to put a question into the queue for asking, just type stack into the chat. That's why that's there. I would like to continue to record this. So if that's okay with you, Erica, I'm gonna continue to record, and I'll unmute you too. So go ahead, Erica, please.
Hi, I'm Erica. I'm a graduate student at CUNY Hunter, and I'm in the program actually to become a public school teacher. So this conversation has been very illuminating and relevant to my upcoming life in many ways. And I just wanted to, I didn't quite have a question, but more of a response to a question that I've been hearing. And that is about how students would be affected by a grade strike, or any form of, I think it could apply to any form of pushback by our staff and faculty. And I think that it's something that if done properly, it could happen with student support, and it should happen with student support. And I don't see why it wouldn't, as long as it's done collaboratively. After all, the things that affect our professors and our faculty and our staff are things that affect, and teachers, it affects the students as well. And a good example of that is what's going on at the Hunter College campus schools, right? The teachers are not only concerned for their safety, they're concerned for their students' safety. And so, this idea of us having opposing interests, this is something that is pushed by misleadership and the powers that be, and it's a tool of division. And so it is important to think about how to not have adverse reactions, or have an adverse effect rather, upon students with action. But I would just say concretely that if it could be done collaboratively, there's a number of these student organizing groups. I'm personally involved in one called Free CUNY, which I'm sure many of you are familiar with. And I think that if it's just done collaboratively, even to extend as far as, staff workers, things like custodial workers, many of our demands, they're different, but in essence, they're very similar. So I think just collaborating, doing it collaboratively is the best course of action.
Yeah, so did anybody have anything that you wanted to say about that? I do certainly, but I'd rather hear from you first. Or Vince, maybe since you were asking about that.
Okay. Yeah,
Mm.
I'm just thinking about the nature of the faculty, the nature of our students at Baruch College, which is a singular institution, really business oriented. The faculty, by and large, are not chomping at the bit to be the spark. You know, whether it is to address the question on campus or to create a broader movement. And I would say neither are the students. They want their degrees, they want their careers, they want their. So part of the job of a union is to raise consciousness, is to get people to think about interests beyond their own. But I think that is a real handicap, or a real a barrier that we have to face, and is that you know, as professional white collar employees who don't even think of themselves as employees, we're professionals. We do our own research. The mindset, I think, as Mark mentioned, is really far from taking this militant kind of action in most circumstances. So yes, I think that students and faculty, you know, our teaching conditions, our working conditions, are their learning conditions. I agree with that kind of assessment of our mutual interests. But the reality too is that you know, they all also have a mutual interest to not rock the boat, to go to the mat with this strike weapon and incur the costs. So we have to deal with that aspect of our membership as well. Thank you.
Mark, did you want to say something about that?
So, I mean, the idea of acting collaboratively, there's a term now that's floating around the labor movement called bargaining for the public good. But the Taylor Law is specifically written to prevent that. It is written to restrict the union to matters of money and specific work conditions. So again, this is the need to like figure out ways to go beyond the Taylor Law and to go beyond the restrictions of the Taylor Law if we are going to you know, fundamentally change the system.
Yeah, I mean, I think of I'm curious about the philosophy behind the no strike clause, because it seems to me that it has to do with public safety, that phrase that's been floated around quite a bit this summer. But in terms of the safety strike with UFT, and then also later on with the Hunter College Campus School, that everybody was in agreement here, faculty and students, that, you know, this was collectively for public safety. The strike was actually more on the side of public safety than the Taylor Law would be, for instance. So did anybody else want to speak about that a little bit further?
Yeah, can I just jump in for a second?
Yes, please.
Yeah, very, very quickly. I think the student interests and the staff or faculty interests coincide. The Chicago teachers certainly proved that in their two strikes in 2012 and 2019. They weren't just asking for higher wages, although certainly they wanted higher wages. That's the one thing in 2019 that the mayor seemed to be okay with. It was calling for things like social worker in every school, lower class size, which they also got in the LA strike. So when the communities come together in these situations, you'll find a lot of community support for K-12, a lot of parent support, and amongst the high schools, at least, a lot of student support. And I think that would work for the colleges also, in terms of getting the interests that are aligned with the students and the professors, and it can be very, very successful.
Thank you, James. Claire Lahane, you're up next. Oh, need to unmute you, don't I? Where are you? Hi, Claire, please.
Hi, Professor.
Hi.
So I think everyone kind of touched on my first question of how students would be affected by the strike, but I want to know, how can we get involved in the strike? What can we do to help? How is that gonna, and then how is that gonna affect our schooling?
Good question, Claire.
Well, Claire, can I turn that back around on you? I mean, there is no strike now, right? What do you think a strike would be about that students would want to be involved in? And then how would you imagine them involved if you could wave your magic wand?
Sorry about that. I think I got muted again. That's a good question. I mean, right now, you know, we are at home, unfortunately. So I'm not even sure what a strike could look like with the student body online. Do you have any ideas?
A student strike online?
Yeah.
Well, in the chat, there was a petition had been up. Erica's saying there's been talk of a tuition strike. Actually, I'm gonna let Erica talk about that. Erica, can you unmute yourself? Or I have to unmute you again? Here we go.
Yeah, thanks. So I don't have too much to report on it, but in Free CUNY had for the leading up to this semester that's currently happening, they were trying to organize around having tuition strike. I mean, you know, it's very difficult because, well, it was just very difficult to get people to commit, and I've missed a few meetings, so I'm not sure. And maybe there's someone who's here who could actually give a better update if there's anyone Free CUNY affiliated. But it was just one idea that was flouted, and basically just the idea of it is that students withhold their tuition as a form of you know, of action.
I think
Can I mention CUNY Rising as an organization in which students are very active, and so the Student Rising group at Baruch participated in demonstrations when we were on campus, and also the student government is also a force to be reckoned with. In fact, administration often pays attention to student discontent more so than employee discontent. And so to raise these concerns, whether it was the presence of the CIA on the Baruch campus, or the lack of a contract for their professors, and the lack of a living wage for their adjunct professors, this was something that the students found reprehensible, and so they made their voices heard in many ways. And so short of a strike, but I think look into the CUNY Rising and student government.
Right, and Erica brought up free CUNY. Joan, did you want to speak about that? Whoops. Okay, I guess Joan, you put up the petition, but did you want? Oh, they.
Oh, I'm so sorry. Sorry,
No, no.
Sorry, I was adjusting my screen. Apologies. Yes, there is a petition that the rank and file action group has that students can sign that says that if there's a strike, they would support it. And I do want to mention that, we have a strike action committee on our campus at Hostos Community College. And we've been talking, we have somebody in our group that also teaches at City. And, they have 100 students in the class. So I think that, the bigger issue is the whole dismantling and austerity that's taking place at CUNY, along with the health and safety issues. And I think that it's really all about the students, actually. So I would say the disadvantage, of course, is that we're, virtual. But the other thing is, because we're virtual, it's kind of easier for people to meet and to come to these mass meetings, and people from different schools can meet with each other. But I would say definitely trying to do two things. I mean, with the faculty, we're trying to do the strike authorization vote, which seems like it's gaining steam. And certainly this forum is very helpful. And then I think with the students, trying to really push this pledge about supporting a strike, but also understanding that I believe the strike is mainly about them and secondarily about us.
Yeah, Claire, I mean, I think it's your participation, your part in it is what's going to decide how it goes. Yes, we are all virtual right now, but I think that part of the defeating the Taylor law really has to do with the public perception that Marc brought up, and the idea of bargaining for the public good. I mean, I think this is a general public good for students and for faculty. I think so. Up next is Tom Waters. You've been on Stack for a long time, Tom. Go ahead.
Thanks, Ian. My question is about, and this is a thorny question, of course, because these decisions are shaped by case law. But my question is about the constitutionality of the Taylor law's prohibition on strikes in general. And I ask this question in light of the Supreme Court's Janus versus Ask Me ruling, which a lot of us on here will be familiar with. To just recap that really briefly, public sector unions after the Janus versus Ask Me ruling can no longer compel non-members to pay what they call an agency fee, which is basically a replacement for dues. Now, the Supreme Court's ruling in Janus versus Ask Me says that the reason that these workers can no longer be compelled to pay dues if they don't explicitly join the union is because all union speech, including collective bargaining, is inherently political because it petitions state, local, and federal government on many different issues related to budget, and these issues are considered matters of public concern. Now, the previous ruling, Abood versus Detroit Board of Education back in the 70s, basically required unions to split their money into two pots, right? That some money would be used for matters concerning the daily life of the union, like collective bargaining, and that wasn't, quote, political. But then if they wanted to donate to, say, Democratic politicians, that would be political. Now, under Janus versus AFSCME, the Supreme Court said that's not good enough because all union activity, at least if it's a public sector union, is inherently political. Now, the conservative wing was basically saying, okay, so you can't charge these non-members agency fees because that's a violation of their First Amendment rights, because that would equate to compelled political speech, even if those dues are being used for something as normal as collective bargaining. So my question is, in light of that ruling, if collective bargaining by public sector unions is inherently political and therefore protected by the First Amendment, how is something like a strike or withholding our labor not also considered inherently political, and therefore a prohibition on strikes would be an abridgment of First Amendment rights by union members? Now, again, I realize this is kind of a cerebral question, and these things are only challenged by breaking that law, because you can't sue unless you have standing. But I wonder if anybody has encountered any arguments about this, or any kind of thinking from like the labor law sector on this issue. Thank you.
You know, there were people. So Tom has talked about this court case, Janus, and in which the majority ruled that restricted the ability of unions to collect funds from people that they were nevertheless obliged to represent. And it was pretty clear that the majority's purpose was to kneecap, to handicap unions and make it more difficult. And there were labor lawyers who felt that the minority, so the minority said, well, we should still continue to allow unions to collect these funds, because we've had, as a result of the law, as a result of their ability to do this, we've had decades and decades of labor peace. And so we should just keep things in the status quo. And there were labor lawyers at the time that said that the minority should have been much more, let's call it expansive, should have staked out the position that Tom is talking about, should have said, oh yeah, well, if you think this is speech, then strikes are speech too. And how can you prohibit strikes if they are speech as well? And certainly, like, I think, Tom, if we were on the moon, as it were, if we were in some neutral, situation, that this is a good and interesting argument to make. But, I think it would be delusional to think that in the present political circumstances, that's a winning legal argument, right? So it may be a good moral argument, although complicated, right? It's not catchy. It's not something you can sum up in 15 seconds, as opposed to like just saying workers should have the right to strike. But I think that imagining that PSC or any other union could strike and then go to this Supreme Court and get them to rule that it was free speech, I think that's, that won't happen, right? The Supreme Court is a political body which is doing political things, and they'll find a way to differentiate.
Yeah, I mean, part of one of my questions had to do with, is there anything good about the Taylor law? People talk about the Tri-Bar Amendment, which is the part about keeping the contract indefinitely, which James brought up. The Buffalo teachers didn't have a contract for 10 years, and keeping the status quo. And it seems to me like, although there has been argument that there might be good things about that, there isn't. And it also that defeating the law kind of with its own logic, even if that logically is possible, or legally kind of in legal logic, the PERB is not going to, they're one-sided. So it's a double-edged sword. Okay, yeah, everything's a double-edged sword.
So I think James had talked earlier about how many unions are the union as institutions actually are reluctant to give up on the Taylor law as it is. Unions were actually given this opportunity in 1977. The governor at the time, a gentleman called Hugh Carey, was talking about Taylor law revisions, and he offered the public employee unions of the state basically the opportunity to take all union fines off the table. In other words, there would still have been this fine for individual workers for striking, which workers have largely shown that they're pretty impervious to. But the union fines would be taken off the table. The loss of checkoff would be taken off the table, and in return, government entities, cities, state, towns, CUNY, would have had the right to unilaterally change contracts at their expiration. In other words, it would look like what private sector labor laws like, and the unions turned this down, right? The unions did not want any part of this discussion. Now, I think that's a mistake, but it just it goes to kind of the culture that existed at the time, and I think still exists in most unions, that the union leaderships tend to think of this as a good trade-off.
Thank you. Next up is Max Baylor. Balton, I'm sorry.
That's perfectly fine. Yeah, thanks, Ian, and thanks for having me. I'm doing an audio documentary on Taylor Law, but I'm also a CUNY student myself. I went to City College and at the CUNY J School. And I had one thought and then a question. Ian, you mentioned the public safety philosophy behind strike prohibition. My understanding with George Taylor, who the Taylor Law is named after, is that he was sent in to deal with an electrician strike at Cape Canaveral during the space race. And that sort of had this grander sense of, oh, this one group can strike and it's going to spell doom for the entire country. So that's my understanding is that's where he got this sort of anti-strike philosophy in terms of public safety, which I think is kind of interesting. But that's obviously a very different scope than what we're dealing with now. So my question, when it comes to public workers, and one of the biggest confusions I have with Taylor Law is why the Taylor Commission doesn't differentiate between public workers. I mean, there's a very big difference between a firefighter versus a teacher versus a bureaucrat. And like what we've been talking about, we've been talking about transit workers strikes and teacher strikes. And I'm curious about, because I think when we're thinking about public safety and public workers, firefighters and cops really come up on one side of it. And then there's the rest. So it's why is there not a differentiation between those groups? And is a change in the law to differentiate between them some way to sort of benefit teachers on some level or any other sort of public workers, transit workers, whatever else?
It's a great question.
Vince, you want to take a shot at that?
Me? I was multitasking, but I did hear the question and I had thought of it as well. And I want to get nurses into there. Nurses often take a lot of heat. They're leaving their patients to die when they strike. So this public safety issue also ties into my point about public support, community support. To what degree do you lose it by abandoning your responsibilities as a subway driver or as a fireman? And so I just want to get that into the calculation, not just the punishment levied through the Taylor Law, but the fact that one can actually be playing into the hands of your opponents, your anti-labor opponents. Yes, please strike, please violate the law, please alienate yourself from the community, and please let us take you down and cripple your union with fines and with the repeal of the Triborough amendments. Some hardcore anti-labor people think that's abominable, and that once the contract ends, all provisions and wages should end, and don't give them that great benefit. So I just think this is part of the calculation about what are the costs and benefits of challenging this law.
I will add, Max, that in this 1977 moment, three groups were exempted from these provisions that would have allowed unions more leeway to strike police, fire, and actually public sewage workers, the people that run the water treatment facilities, were deemed the three groups that affect the public health in immediate ways. But again, you know, this is like Tom's argument, right? These are, you know, we have to understand the politics as well as the logic. And the tailor law was meant to stop strikes, not just to stop strikes against, you know, that would harm, that would put public safety in peril.
Yeah, it seems like it all comes down to public perception and bargaining for the public good. You know, even with these historical precedents, it's nonetheless, these were considered wins, but they also, you know, had severe penalties for the unions involved.
The ILO did differentiate between those absolutely essential services like police and fire and everybody else. And I think that we shouldn't be afraid of public wrath. And I just think of Western Europe, where they wouldn't care. And I don't know if I said this before, but in 1975, at the height of the financial crisis, Albert Shanker was asked, why don't you do a general strike? That would wake everybody up. And his answer was, well, that's what communist unions in Europe do, and that would be irresponsible. Well, I think we talked about it a little in 2005 before the UFT gave up a lot in that contract, but I think it's got to come about again. There's nothing wrong with unions combining and thinking about that kind of action, and general strike, it could work.
Yeah, I called it psychological. We could call it cultural. There's no question, and Vince has raised this correctly, right? That there are our mindset as union members, our mindset in the public is against striking, and you can actually, but you could actually see in this Hunter Campus Schools example, I think that ultimately CUNY gave in after 3 months of stonewalling. CUNY gave in because this would have been, because they don't want to open the door to, they're very satisfied with this situation as it is, where workers think, well, you know, I can't strike, or there's too many costs, right? Just kind of think about it that way automatically. Unions think, well, you know, we have no experience striking. And CUNY, I think, very rationally from their standpoint, decided that it was much better for them to make the concessions here that the union was demanding in order to open the school than potentially see a successful strike take place.
Yeah, and I think the success of these strikes has to do with that they're coming from the membership. Like you mentioned, James, about the UFT strike, and Mark, you mentioned about the Hunter College Campus School strike also. It's definitely coming from the rank and file membership, and that pressure means something. So that's and public perception is also involved with that, and that's the main impetus behind this whole teaching today. I think we're gonna have to be finishing up soon, but there is, well, Christina Morales, did you want to ask, you were asking about the situation in Illinois or in Chicago, whether there was laws preventing strikes there. And then Alexander Wolf, I also saw that you're on there, Stack.
Do you want to answer for that one? The Chicago question?
Yes.
Okay, in Chicago, in Illinois, they passed a specific law for Chicago teachers that required a 75% strike authorization agreement of the entire membership. And then they said they were only allowed to bargain in any kind of strike situation over wages. Well, they got something like 90% in both of the 2012 and 2019 strike authorization, 90% of the membership, not 90% of those voting. So the union took care of that. And in terms of their bargaining, in 2012, the corporate newspapers, the Tribune and Sun-Times, wanted them to get an injunction because they were going way beyond what they were supposed to legally bargain for. They never did. And in 2019, when they again were bargaining way beyond the scope of wages, they never got an injunction, and it wasn't even talked about much in 2019. So there are limitations, but as teachers have shown throughout this country, the limitations don't matter. If you got the public support, got the teachers behind you, you can win.
Yeah, I mean, that again, a legalistic route that seems more reasonable. If 75% are behind it, then you have a clear majority there. Did you want to speak or ask any more, Christina?
Do you know if there are similar laws, I guess more broadly, in other states where teachers or other publicly funded employees have gone on strike, like somebody mentioned Virginia?
It's wildly diverse. It's from state to state. So Alexander talked about how there's this particular law that was passed in Illinois, but on the other hand, the strike itself there is legal. There are no particular fines or penalties for going on strike. That's true in California too. But on the other hand, we saw strikes in teacher strikes in West Virginia and in Arizona and in Oklahoma, where the laws don't even allow unions supposedly to collectively bargain over wages and working conditions, let alone strike. And they were successful or partially successful. So it's all public employees operate under all private sector employees operate under one set of federal laws. All public employees operate under their own set of state laws.
Thank you.
And I think the Graduate Students Union in Michigan, the recent strike there, they were somebody who might know more about this, please put yourself in Stag, but you know, it's illegal for educators to strike, I think in Michigan, or, you know, there was also a similar kind of legal restriction on them.
Yeah, it's illegal if you lose, right? I mean, that's a way to think about it too, right? James had talked about Condon-Wadlin, and transit workers in 1966 struck against Condon-Wadlin, and when the legislature said, well, now we're going to consider what penalties to impose, the locals said, well, we're going back out then. And they scurried to exempt the union from those laws. So, and in 1980 also, in the transit workers strike then, there was an odd strike because the leadership had been against the strike, and it was really forced by rank and file oppositionists. And there was discussion going on between the state and those oppositionists actually about how to how to give workers extra money that would have paid off the Taylor Law fines as to end the strike, so that it would kind of be nod and wink. The Taylor Law still exists, but it wouldn't have impacted. So, you know, Vince is right. There are real costs, right, with the law now. But I just would argue that we're in a really amazing moment in this country, and things that have not seemed possible, maybe are possible now. And we should be open to the opportunities when we see them exist. Just as we're trying to desperately fight off the opportunities that the right and the fascists see existing for them as well.
Can I take a moment and just agree that this is a new moment, this COVID moment, when we have issues like campus reopenings and safety, class sizes expanding, mass layoffs and loss of health insurance, you know, we're not the F word, furloughs, pay cuts. We're not even bringing these horror scenarios to bear, but they may be part of our reality in the near future, in which case our response to them may require new choices and new options. So I think this discussion is very important given the changing scene in academia and in CUNY in particular.
Thank you. Go ahead, Alex.
Hi, I'm Alex. I teach at Bronx Community College. I'm a member of the PSC and also a member of Rank and File Action, RAFA, which is you know, the dissident sort of group within the PSC that has been pushing for many years to have a more militant response to the various cutbacks going back to, you know, our last contract. I wanted to you know, sort of reiterate something that Marc said, which is that, you know, really this is all about mindset. This is all about how workers are feeling, you know, CUNY workers and students are feeling. The Taylor Law is not the first anti-worker law, right? I mean, labor historians, I am not a labor historian, I'm a biologist, but you don't have to be a labor historian to know that there have been hundreds, perhaps thousands of laws that have, you know, been enacted to limit the power of workers. The difference now, I think, is that we are at a point when the mindset among workers, you know, talking about solidarity, talking about militancy, talking about class consciousness, these things are perhaps at an all-time low. You know, workers in the past, we're not too far from the 99th anniversary of the Battle of Blair Mountain, which, you know, for those who don't know, was a fight. And when I say fight, I mean a fight with guns between coal miners in West Virginia and the US government. So, you know, workers have fought back against unjust laws in ways that are hard to imagine. And what I think we need to do is see this as practice, right? We need to rebuild that mindset, that class consciousness and militancy and solidarity. And it's going to be you know, an uphill battle, a hard road to go, but that's our only way forward. You know, we can't rely on the election. My feeling is that whoever wins in November, the situation for our students and for our precarious faculty is going to be pretty much the same. It's up to us, is what I'm saying. And we need to practice. And as part of that practice, I would like to invite everyone to come to the Bronx on Friday at 3:30. I put the flyer in the chat. We're having a demonstration against these racist cutbacks at CUNY. It's being organized by Hostos and BCC students and faculty and staff. And, you know, this is our practice. This is our practice for fighting against unjust laws, for fighting, you know, for what we deserve as faculty and students. So again, Friday at 3:30 on 161st and Grand Concourse, I invite everyone to come out, bring a sign, bring your mask. we're going to march down to the housing court and make some noise. So please come out. Thank you.
Yeah. So everybody, I don't know, does anybody have anything else to add to that? That was great, Alex. Thank you. Yeah, so we need to talk about this. This is part of building community as best we can these days. And thank you everybody for coming. I really appreciate all the great questions and all the scholarship and thinking and discussion of the Taylor Law. And especially to Mark and Vince and James, very, very big thank you.
Thank you, Ian, and I hope your students learned something about research inquiries.
I hope so.
Thanks, Ian. Appreciate the opportunity to speak and be part of this.
Yeah, thank you.
Thank you.
Mm-hmm. This is what my daughter does when they want to clap on her online class. Thank you.